Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific Time, 1 p.m. Eastern Time to start off our week of handling trusts, estates, probates with an opportunity to share some knowledge and get better at what we do. So today I'm going to talk about something called a surety bond. Now, for those of you who are old hands at this, you probably have dealt with surety bonds. But for those who are new, or if you're tuning in for information about your own estate plan, it's good to know about surety bonds because it can have a significant impact on how your estate is handled, on who handles it, and most definitely on what it costs to handle your estate. So I'm going to bring up. I did a little presentation this time. So the what, when, and why of surety bonds. Okay, pretty straightforward there. And you see here, as is always the case, everything on the Way to Wow shows relates to the three pillars of attainment. We're dealing here in the finances realm of the pursuits pillar. And if you want more information about that, please go to our YouTube channel, youtube.com/at the way to wow. And I have an episode on that specifically. So let's start out with what is a surety bond? Okay, so a surety bond is a type of insurance. Now, most insurance companies do not issue surety bonds. So, typical like Farmers, Allstate, those are not bonding companies. Now, while a surety is a type of insurance, typically it will be a bonding company, an insurance company that specializes in bonds, that is the actual issuer of the surety bond. Okay. And there are three parties to a surety bond. First is the principal. So the principal is the individual who needs the bond. They're being required by another party to have a surety bond in place in order to fill a particular role, typically. Okay. The obligee or the obligee is the party that requires the bond. Now, this will typically be a court, as you'll see when we talk about when a bond is required. Okay. And when we talk in the context of trusts and estates, so the obligee or obligee, I'm not sure how it's pronounced. The spell checker didn't even say it was a legitimate word, although it is. I guess it's the obligee is the party requiring the bond. And then you have the surety, which is the party that issues the bond. That's the bonding company or the insurance company. Okay. And they're on the hook for the amount of the bond, whatever it is, $1 million, $10 million, etc. Okay. So keep this. This is a little bit different than a lot of insurance policies. So if you think about your auto insurance, you don't really think of it as having three parties. You think of it as having two parties. There's the principal, you, who wants the auto insurance or needs the auto insurance, and there's the insurance company that issues it. However, in most, if not all states, there actually is an obligee, and that is the state. Like here in California, we're required to have a minimum amount of automobile insurance. I believe it's 30,000, 15,000, 5,000, or I mean 15,000, 30,000, 5,000. So a minimum of 15,000 in liability coverage for one accident, an overall limit of 30,000, and then I think it's 5,000 for property damage or something like that. So if you're driving without insurance, that's grounds for a citation minimally. Okay. In other types of insurance, there is no obligee. You are, if you own your house outright, in other words, you have no lender on your house, you're not obligated to have fire insurance, for example. Okay. Now, if you have a lender, they're going to require you to have insurance so that if the house burns down, they'll get their loan paid back. But typically in insurance policies, regular insurance policies, there won't necessarily be an obligee. But in a surety bond situation, there always will be. Okay, next. When do you need a surety bond? So you'll for an estate situation, you'll need a surety bond when there's an executor or an administrator. Now, notice it doesn't say when there's a trustee. So if you have a trust and you pass away and there's a successor trustee, unless you require it in your trust, which most trusts don't, it's one of the advantages of having a trust, there will not be a surety bond in a trustee situation. However, when there's an executor, in other words, there's a will and it's going through probate, or there's an administrator, either because there's a will, but the executor, for one reason or another, either cannot or does not want to administer the estate, and so someone else is appointed to do so, or the person died intestate. You see that they're in point number 3, and so there is no will, and so the court is overseeing the probate of the decedent's estate. So in many cases, a surety bond will be required. Now, let me add that I say in many cases, but not in all. So in some cases, the estate can file to have the requirement for a surety bond waived. So I've had that happen in my career, where I was appointed as an administrator for an estate, at least for the part that was going through probate. Okay, it wasn't a lot in terms of dollar amount of what I was going to be administrating, and so we applied to have the bond waived. And in this particular case, the court granted the waiver. Okay, had they not, I would have had to have gotten a bond. It was, I think the total amount was under $1 million in terms of what I was administrating. The cost of the bond wouldn't have been a whole lot, but it still would have been a cost. Okay, and generally speaking, the cost of a bond is about 0.1% of the bond amount. So on $1 million, that would be, let's see, 1,000,000, 100,000, 10,000, be about $1,000. Okay. So, I mean, you could say, well, against $1 million, $1,000 isn't a lot of money. No, it's not. But on the other hand, why pay $1,000 to the bonding company if the parties are willing to waive or don't see a need for the bond and the court is willing to waive it? Okay, so it isn't the case that every time there's an executor or an administrator, a bond is required, but in many cases it will be. Now, when will it be? Well, first of all, when state law requires it. Okay, so in certain, and this varies from state to state, as does all the laws relating to probate and estates, etc. So if state law requires that an executor or an administrator have a bond, and there isn't a provision in that law for the judge to have discretion to waive it, so then there's going to have to be a surety bond. That's just the bottom line. Okay. Another situation where a bond may be required is with a large or complex estate. Okay. So if an estate, and this, by the way, will connect to the fourth one, the executor or administrator's financial condition. So if you've got an estate with $50 million of assets, let's say $25 million of assets, okay? And the executor has a net worth of, let's say, $500,000. So in that case, it's very likely that the executor will be required to get a surety bond because the executor does not have the financial wherewithal to compensate the estate anything close to it if he makes some kind of mistake, etc. Okay, and we'll talk about that a little bit more under the next slide, why. Okay, but the larger and the more complex the estate, okay, the greater the amount of knowledge and liability that the executor or the administrator is carrying, and therefore the more likely it'll be that a bond requirement will be imposed. Okay, so that's just something to keep in mind. Now, by the way, let's say a $25 million bond, right? The cost of that bond is going to be $25,000 or thereabouts. I mean, it can vary a little bit. But you can see that, that's a big expense. Again, it's against the overall value of the state. It's still 0.1%, but still $25,000. That's a pretty large expense. Okay. But it may very is often the case with insurance, it may very well be worth it, okay, depending on what the situations are. Okay, if the decedent dies intestate, okay, so in that case there won't be an executor because there was no will appointing an executor, but the court will appoint an administrator, okay, and in that case, in the case of an administrator appointed to handle an intestate estate, it's very likely there's going to be a bond requirement. Now, depending on what the state is comprised of and the breadth of authority the administrator has, that will have an impact on the size of the bond. So let's say you have an estate and it's overall it's worth $10 million. Okay. And let's say $3 million of that is liquid assets, things like cash, stocks, bonds, etc. And the other $7 million is real estate. Okay. And let's say that the administrator, instead of being given essentially unlimited authority, the administrator has authority to do everything except sell or encumber the real estate. Encumber means like put a loan on the real estate. In that case, the bond may be reduced from $10 million, the overall value of the estate, to $3 million, okay? Since the administrator only has unlimited authority over the liquid assets, that's really what's in danger. Since the administrator cannot sell the real estate without the court's approval, there's very little chance that anything nefarious can be done in that regard. The court's going to be involved, okay, and so the court may not impose a bonding requirement on that portion of the estate because in this case the administrator's authority has been limited with respect to the real estate. Okay, so all of those factors can play into the size of the bond. Okay, now you may be thinking, well, what would happen if the estate only had real estate, right? And the administrator, had limited authority, in other words, couldn't sell or encumber the real estate. Would the bond be waived? I suppose it's possible. I haven't seen a situation like that. And when you think about it, there's probably, if there's real estate, unless it's some kind of non-income producing real estate, there's going to be at least some cash lying around and probably some other types of assets. Okay, but in any event, if the authority of the administrator is limited, so then that may reduce the size of the bond required. Okay, and then I mentioned before, talking about larger complex estates, the executors, I should have said, or administrator's financial condition may also have an impact on whether there's a bond and how much the bond will be. So let's say you've got a family situation where let's say there's 3 children, and only one of them has been appointed executor, and it just so happens that the one appointed executor doesn't happen to have a lot of assets. Okay, so it may be that the court will impose a bond on that child due to the fact that he has, few assets. He's the executor under the will, but because he doesn't have any kind of financial wherewithal, so then the court is going to make sure that a surety bond is put in place in order to confirm his appointment as executor. Okay, and I should quickly mention that merely because a will specifies an executor, that does not give that person authority the moment that the writer of the will dies. So when the decedent dies, the executor still has to open a probate, and one of the first activities that will happen with respect to the probate will be the confirmation of that executor as the executor. Okay, so it's by no means automatic in the sense that the person dies and now the executor takes over. The court is going to appoint the executor officially and issue letters of administration to the executor. Okay, and until the executor has those letters of administration, the executor cannot officially act on behalf of the estate. Okay, so that's the when of surety bonds. Okay, and the why. So there's essentially 2 whys. They're interrelated, and it really comes down to the surety bond is financial protection to the obligee against the principal's failure to perform or against malfeasance. So let's take a situation where okay, so we have an estate being administered by an executor, and the executor is not particularly well versed in financial matters, and as a result, the estate takes a significant loss. Let's say the executor doesn't maintain the insurance on a property. Okay, the insurance lapses, and the property burns down. Okay, and now there's, the property is worth a lot less than it would have been with, the building whole. Okay, so that's not, assuming it wasn't, the administrator didn't do it on purpose. That's not malfeasance. But it is the principal's failure to perform. And so in a situation like that, the bond issuer, the bonding company, the insurance company, would probably get a claim filed against it in order to make the estate whole. Okay, that's what they're there for. So when someone applies for a bond, one of the things that's going to be looked at is, as you would guess from the previous slide, what is the financial condition of the principal, the person who needs the bond? But also, what is their background? What kind of work have they done? How experienced are they in acting, in handling financial matters, and in particular in acting as an administrator or an executor? Okay, and so that's by the way, not to toot my own horn. This is true in general. So for professional fiduciaries, because it's our business, right? There's less questioning in terms of, well, does this person who's applying for the bond, do they know what they're doing? It's what we do, right? And so there's typically, if for a licensee, there's typically a presumption that they know how to handle these things. Okay. Now, of course, merely because someone has a license doesn't mean that they won't commit malfeasance. There's always temptations, right? And of course, malfeasance is, the principal doing something on purpose. So let's say, for example, the principal stole. So let's say there was a valuable collection, a coin collection, okay, and the principal, in going through the personal effects of the decedent, finds the coin collection and steals it, essentially. Okay, and so then the estate, the administration of the estate is going on. And at some point, somebody says, "Gee, I thought Bob had a big coin collection. What happened to it?" And there's an investigation made, and it's gone. And it turns out so is the administrator. He absconded with the coin collection. Okay, so that's malfeasance. And in that case, too, the bonding company would probably find that a claim is filed in order to recover the value of that coin collection, assuming it was known what it is. Okay. So who's being protected? Well, in the end, it's the beneficiaries that are being protected. So although the court may be the obligee, the court may be the one requiring that the executor or administrator post a bond or get a bond, same thing, post a bond, okay? The court is doing so to protect the beneficiaries, okay? So, especially if the beneficiaries are not particularly sophisticated in financial matters, certainly if they're minors, okay? And so, they don't have the ability to handle these kind of matters because they're not at least 18 years old. So in that case, the court is going to impose the bond requirement in order to protect those people who are supposed to be getting the proceeds of the estate. Okay, just real quickly, right? The probate process is one of the executor or administrator, first of all, performing an inventory of all the assets of the estate, right? I've talked about this more broadly in another episode. You can look it up, but gather the assets of the estate, find out what debts are owed, value the assets, pay the debts, and then distribute the remaining assets of the estate. In very simplified form, that's what the administrator or the executor does. Who are getting the distributions? It's the beneficiaries. There could be one, there could be several. It depends on the estate. Okay, so it is to protect those individuals that the bond is posted. Now, what happens once the probate is closed? That's it. The bond is done. Okay, the premium is earned, and if there was no claim, so good for the bonding company. I mean, that's why, by the way, you can see at 0.1%, right? Bonding companies are not paying off very often. If they had to, they couldn't stay in business, right? So that's the idea behind the bond. Now, by the way, I should add that typically bond premiums are annual premiums. So if it takes more than a year for the estate to go through probate, another premium may come due in order to renew the bond for a second year. Okay, it just depends how the bond is written, but typically that's how it's done, and it makes sense. The longer the bonding company has their money at risk, the more premium they're going to want to collect in order to make sure that they're able to pay their claims. In the same way that we don't pay a one-time premium to get an automobile insurance policy, right? We pay a I mean, annual, or it could be every 6 months, whatever your policy requires. It's an ongoing premium in essence. Okay, so the same is true for a surety bond. Okay, so that's not a particularly complex subject, but it is something that you should know about. And by the way, going back to what I said at the beginning, one of the reasons for having a trust is you can avoid the bonding requirement if you choose to, because with a trust, the court will not be involved in the administration of your estate. So the court will not have the authority to impose a bond on your successor trustee. Now, that isn't to say that as part of the instructions of your trust, you can't require a bond. You can. Most trusts waive the bond on the successor trustee in order to preserve the assets of the trust. Okay, but that would be your decision as the grantor or trustor, the person creating the trust. You get to decide it, not the court. Okay, so it's another reason for considering having a trust instead of having just a will. All right, and I think that's it. I'm going to have. Yeah. So if you have any questions, would like some help, as always, these links will be in the show notes. Feel free to drop a question into any of our social media sites, or if it's something personal, you can always email me there at my email address, and I will respond if it's something within my body of knowledge, and if not, I'll let you know. I'll recommend that you consult a lawyer or an accountant or whatever professional it is that can give you the answer. Okay, and then we've got some legal issues here, legal stuff. Okay, we'll go ahead and close this out. And so that's our show for today. And hope you found this useful. It gives you a little bit of background on dealing with surety bonds, and especially if you're planning your own estate. This is a question to ask the people who are advising you. What may or may not be necessary with respect to a surety bond at the time my estate is administered. And it should be a pretty easy question for them to answer for you. If they're stumbling over it, oops, maybe time to look for a different advisors. Okay, but it is a question to kind of have on your list because it is a cost to your estate. So thanks very much for joining me today. Tomorrow, my show at 10 a.m. Pacific time is Business Lessons from the Military. And let's see, what is my topic? Oh, so I'm going to be talking about military departments and unified commands. Those sound pretty esoteric, and I think for most of us they are. I'll tell you, before I joined the military, I had no idea there was a difference between the two. I thought, the Navy and the Department of the Navy, they decided, where they were going to fight, or they took orders where they were going to fight. It does not work that way. It's much more complex. And the structure that the military uses to handle the nation's defense, I think, is very instructive for us who are running businesses or who are working for other businesses as well. So do tune into that. And then on Wednesday at 10 a.m. Pacific time, my show, People Making Money, we're going to talk about how to build your real estate portfolio using a concept known as leverage. If you speak to anyone with large real estate holdings, almost for sure they used leverage to build it. Now, leverage can be good and it can be bad. So obviously you want to use leverage in a good way. And so that's what we're going to talk about. And also we're going to talk about sort of what happens if you find yourself in bad or negative leverage. Okay, so do tune in for that. And then 7 days from today, next Monday, we'll be back for the next episode of Trust and Estate Weekly. So thanks very much for joining me today. Wishing you a wonderful rest of the day, and signing off as I always do. Marie, darling, you are my belle. All the best, folks.